Hi, this is Brad Aldrich, and this week's topic is landlord-tenant law. This falls under the gambit of real estate law. One of the first things that, whether you're a landlord or tenant, you should consider is the term of the lease. There are different ways that a lease can come into existence. A tenancy can be created either through a written document, which is commonly referred to as a lease, or a rental agreement. And in that rental agreement, you can set out the specific length of the tenancy. Tenancy can also be created even if there is no written documentation. In other words, if a tenant moves into a property and is paying some type of compensation to stay there, and in return obviously gets possession and use of the property, then a tenancy can also be created that way. There are a few other means by which a tenancy can be created, but they're a little more detailed and obscure and not necessarily good for a topic of the video today. If you wanted more information on that, you can certainly contact us directly to discuss it, but I'm going to discuss the two main types of tenancies that are created. Now, if there is no written agreement regarding the tenancy, meaning there's no lease or rental agreement, then there is a presumption at law that it is a month-to-month tenancy, meaning that the tenancy can be terminated by either the landlord or the tenant by the simple giving of a 30-day notice, meaning you have to give a notice in writing equivalent to the length of the lease, which if it's a month-to-month is obviously 30 days. The most common type is when there is some type of written lease agreement or rental agreement, and that lease should contain certain information. Now, even prior to a lease being signed, both parties should talk to an attorney to make sure that there are certain other documents that are provided. Some of those would be certain disclosures that the landlord has to provide, such as lead-based paint, the condition of the property, etc. And both parties should use an inventory checklist. We recommend an inventory checklist because it can set out the condition of the property at the time the tenant is taking possession, so that when the tenant does in fact vacate the premises, both parties can look back on the inventory checklist and determine whether or not there were any damages beyond wear and tear that the tenant would be responsible for. It helps clarify those issues so that in the event of a dispute, there is some type of written documentation to help clarify that. The lease itself should have some very specific terms in there, such as who's responsible for utilities, who's responsible for making certain repairs, whether or not the tenant is allowed to sublease a portion or all of the property, and whether there's going to be a security deposit and how much. Now, please understand that there are specific information that needs to be put into a lease so that it complies with state law, certain federal regulations, and perhaps local ordinances depending on the city or the township. And that's where it's imperative that either as a landlord or a tenant, you contact an attorney to make sure that that lease has the correct information and doesn't in fact have something in there that violates one of these either statutes or local ordinances. Now, in the event that there is some type of a dispute that arises between the landlord and the tenant, an eviction may start. This is where the landlord is trying to recover possession of the property and perhaps get a money judgment against the tenant. Now, there are two main types of evictions. The first is where the landlord is saying, I just simply want you out of the property. And that could be either because the lease term has expired, they don't want to renew, or there's been some type of breach of the lease, like perhaps the tenant was doing some type of illegal activity on the premises, or was being disruptive, or causing some type of damage. In the event that that occurred, the landlord could send what's called a notice to quit, termination of tenancy, which is commonly referred to as a 30-day notice. And at the expiration of that 30-day period, if the tenant has not voluntarily moved, then the landlord can file an eviction suit in the district court, which is typically by city or township, that the property is contained in. The other type of eviction is where the tenant has failed to pay rent or some other type of expense that is their responsibility. And in that case, the landlord would give what's called a demand for possession non-payment of rent, and that's typically referred to as a 7-day notice, meaning it gives the tenant 7 days to pay that which you're supposed to under the lease, and in the event they do not, the landlord can then file an eviction case, and the process for whether it is a 30-day notice or a 7-day notice is pretty much the same, meaning a complaint and a summons is filed at the district court. There's a fee that's paid for the filing fee and for the bailiff fee, and then a process server served the defendant notice telling him of the date of the hearing. Now these are summary proceedings, so they move pretty quick, meaning the parties will be in court within a relatively short period of time. And at that summary proceeding, there will be a hearing to determine whether or not the landlord has a right to possession and perhaps a money judgment. A tenant can retain legal counsel and defend themselves. Some common defenses may be that I didn't pay rent because the landlord wasn't keeping the place in reasonable repair. Another defense may be that the landlord is retaliating against me for something that I did, meaning maybe I contacted some third-party agency, state of Michigan, maybe the local building department, to complain about something. The landlord found out about it and retaliated against me. There are a number of different defenses that may be presented to an eviction, and from a landlord's perspective, they may want to retain counsel because there may be legal issues that are beyond a lay person's capability to handle. And also, as a landlord, if you are a corporation or an LLC or any type of company, you cannot represent yourself. You have to have legal counsel. And in the event that the landlord is successful at the hearing, a judgment, an eviction judgment, will be entered. It's called a judgment of possession, giving the tenant 10 days to vacate. In the event of a non-payment of rent, it gives them 10 days to pay the amount that's due or move. In the event of a termination of tenancy, it simply gives them 10 days to vacate. If the tenant does not vacate within that 10-day period, or pay the amount that is due, then the landlord can apply for an order of eviction, commonly referred to as a writ. And this is where the judge signs the order. It goes to the bailiff department, and a bailiff, a court officer, will come out to the property and physically remove the tenant. Landlords are not allowed to engage in self-help, meaning they cannot physically come out to the property themselves and remove the tenant or their belongings. That has to be done through an order, writ, where a court officer comes out. In the event that a landlord does violate that policy, they can be sued and in trouble, be civilly liable to the tenant. And then finally, there's the issue of security deposit, meaning a landlord can retain a security deposit if there's unpaid rent. If there's not unpaid rent, then they have to send out written notice to the tenant stating what damages occurred to the property. And there are very specific times when the landlord has to send out these notices. If the tenant disputes it, the tenant has to send written notice back within a certain period of time. The tenant must provide forwarding address, etc., etc. My point is that there's a lot of legal steps involved, and we at Aldrich Legal Services specialize in landlord-tenant relations and any type of issues that may arise in the inception of the lease, or whether or not there is some type of eviction. If you'd like more information, please visit our website or contact us directly for a free consultation.